welcome to our webinar on the assignment of benefits, the impact on carriers. My name is Vaughn Lawrence. I'm the Director of Communications here, Director of Communications and Technology for PAMIC. As an organization, a lot of you know that we're focused on providing timely education to our members about issues that directly affect their companies. Today, we're obviously focused on the assignment of benefits, and it's pretty timely given the snowstorm that we just had and some of the impacts that might have on your companies. Before we begin, I want to take some time to thank our sponsors that allow us to do these events throughout the year. Those sponsors are Baker Tilly, Donegal, Gen Re, Guy Carpenter, Markham, Munich Re Hartford Steam Boiler, Mutual Boiler Re, Pennsylvania and Indiana Lumbermen, Swiss Re, and Willis Re. We got two great industry experts here today presenting to you folks. First, I'm going to introduce Michael Zimmerman. Michael has over 30 years of insurance industry experience. He oversees a 23-person claim department handling claims in 8 different states. He's the president-elect of the Pennsylvania Dutch chapter of CPCU and serves on the PAMIC Claims Committee. Next, we have Scott Ribney of Rebar Burnsteel. Scott is a member of the firm's insurance industry law group representing insurance carriers directly for his 18-year career. His practice has a particularly substantive focus on property insurance, including both residential and commercial insurance. His experience also encompasses commercial general liability, D&O, fiduciary, commercial crimes, and credit risk insurance. In addition to be a frequent presenter at PAMIC, Scott has also appeared as paneling in seminars sponsored by the Insurance Society of Philadelphia, the Pennsylvania Defense Institute, and the Defense Research Institute. All the materials that we discussed today and the video of this presentation will be available on our website after this event, and you will also get those in an email. There's a question button that anybody can click throughout the presentation if you want to ask any of our presenters a question throughout, and they will get to you as soon as they can. So I'm going to hand it over now to Scott and Michael to begin the presentation.
Thank you, Vaughn.
Thank you, Vaughn. Good afternoon, everyone. And on behalf of Mike and I, we appreciate you taking the time out of your busy schedules to attend this webinar. As Vaughn was saying, the timing of this is somewhat appropriate given that at least where I'm sitting right now, we have about 12 inches of snow. The temperature's in the 40s, the snow's starting to melt, and within about another 6 hours, we're going to see it freeze, and we all know what happens at that point with ice damming and the resulting claims from contractors or public adjusters. But for today's purpose, we're going to be talking about assignments of benefits. All right. And there's really 4 different items that we're going to be focused on here today. The first, we're going to go over a brief overview of what assignment of benefits are. In my experience, a lot of people have dealt with these in some form of another, but there are some carriers who haven't had the pleasure yet of coming across assignments of benefits, whether it's in the property world or in another line of coverage. We're going to talk about, generally speaking, what impact the assignments of benefits have financially on claim payments, on premiums, how the law treats assignment of benefits in Pennsylvania. I think there are some misconceptions among carriers about whether they're valid or not. We're going to dispel with those here today. We're also going to take a standard assignment of benefits form and dissect it. I'm going to go through point by point and talk about some practice and practical points that you can take away from these forms as part of your adjustment of the claims. Okay, and then last, we're going to talk about what impact assignments of benefits, you may hear people refer to these as AOBs, have on not just your claims investigations, but also the insured and insurer relationship. Let's start with an overview of what an assignment of benefits is. In its simplest form, it's a document that policyholders sign giving rights to a third party to obtain some portion of the benefits under the insurance policy. A lot of times we see these most commonly with public adjusters. But there's been an increase in the number over the past couple of years in assignments of benefits being obtained by contractors in the state of Pennsylvania. Now, most of these assignments are limited to the ability to seek direct payment for the services from the insurance carrier, but some are not, okay? And I'm going to show you right now, this is a standard form. It's available all over the internet that a lot of contractors we've seen use in connection with insurance claims on the property side. We're not going to talk about the details of this now. We're going to come back to it in a little bit and really take this apart line by line, okay? But let's go a little bit about the impact on claims, payments, and premiums. Now, most states don't have a lot of statistics on what exactly the impact of this is, but some states do. Specifically, Florida has the most detailed analysis, financial analysis over years on the impact of assignments of benefits. And I think some of the numbers will be startling for you. Let's just start with the percentage of claims with an assignment of benefits, okay? And what you see here is over the course of, from 2015 to 2017, the claims with an assignment, at least one assignment of benefits, they're increasing every single year. Not surprising, Florida's insurers have also found a concomitant increase in the average severity of the claims that are being presented. Just take a look at the differences there in the chart. If you look at the 2017 figures alone, you're talking at almost a $10,000 difference between the claims where there is an assignment of benefits and there isn't. Now, take that number over what your average pending is. It turns out to be a fairly significant number. But it's also important to note that in Florida, what they also found for the 5 years prior to 2015, when the assignments were there and they were still being hotly contested, but they didn't take off until 2015, the numbers were fairly stable. That's why you don't see anything up here with a chart that predates 2015. Now, there's another financial impact of that to this. That's the impact on the policyholders and the premiums. In Florida, what they're projecting over the next 5 years, and this is for a new home costing $150,000, you can see they're projecting almost a $300 increase per year in the insurance premiums. Now, for some on the phone, you may look at that and say, well, that's not a big deal, but I'm sure there are other mutuals, and you think to your insureds, the geographic area where they live, $300 is a significant amount of money for them. And again, this increase alone is being attributed to, in Florida, only the assignments of benefits. That doesn't take anything else into consideration. It's just this one factor alone. Let's switch over to the law. And I've heard over the past number of years, different people addressing this subject in different ways in Pennsylvania. Are they enforceable? Are they not enforceable? There are some taking the position out there that a post-loss assignment of benefits, which is what we're talking about here, is contrary to the anti-assignment clause in the policy. I will tell you straight up, that is wrong. In Pennsylvania, post-loss assignments are valid, they are enforceable, and they have been for many, many years. I know that there are some on the phone who write in other jurisdictions as well. New Jersey, Maryland, New York. We tried to pick out a couple of states here where we felt that the largest number of PAMIC members also did business, simply to highlight the fact that in these other states that you see on the screen right now, courts allow post-loss assignments. And if there's anybody on the phone thinking, well, you know, I've gotten counsel that says otherwise, here are the three cases in Pennsylvania dealing with assignments of benefits. First case, 1946. We're not going to go into the legality of what these cases stood for and, you know, the facts underlying each. But what I want to highlight here is that starting in 1946, and then again by the Pennsylvania Supreme Court in 2005, and as most recently as October of 2017, where courts have addressed this issue in the context of a property or as a post-loss assignment of benefits, they're coming down on the side of validity. Now, does that mean every time you get an assignment of benefits, you automatically have to deal with whoever obtained that assignment? No, I'm not saying that. And I don't want you to take that away from this. But from a general discussion point, assignments are valid. Now, let me just take one quick break before we go in and dissect this. There is one question that was posed about the fee shifting arrangement within Florida's Florida law. And yes, that is one of the driving factors of assignment of benefits and why contractors and the attorneys really are pressing them. But the other numbers, I think, are hard to refute too when you dive beyond just the number of assignments of benefits and you look at the damage claims. You know, the storm claims figures aren't based on the attorney payouts. They're based strictly on the dollar value of the claim as it's been presented to the insurance company. Now, let's go through this standard assignment of benefits form. And you may see other ones out there, but at least the ones that we've seen generally tend to track this particular form here, okay? Now, in terms of basic contract principles, this is the lawyer side of me kicking in. There has to be something that's bargained for in order for a contract to be valid. And that's really what an assignment is. It's a contract between the insured, and we're just going to talk about the contractor in this case. Although I will tell everybody who's listening that you can see parallels between insureds and, let's say, a body shop who may be working on the insured's vehicle after an accident, or a towing company. Now, those have some slight nuances, so we're not going to dwell on them too much here today. Okay, but there has to be something that's bargained for. So if we start off this assignment, and let's just start right at the very top line here. You know, the undersigned insured and fill in name of contractor in consideration for the services to be performed as defined in the contract signed on blank. Okay. From an adjusting standpoint, it's very important, and we know this, to look at the dates on the contracts. Okay. Is the contract between the contractor and your insured before or after the date of loss? I know that seems somewhat elementary, but you would be surprised how often something as simple as this can be overlooked. Okay? Was the work completed and the contractor paid before the assignment? This is, again, a very critical question that needs to be explored. First and foremost, if the contractor was already paid for the work and then tries to take the assignment afterwards, I would submit to you that there's nothing to assign. I will also tell you that one thing you need to be wary of is how much was the work performed for. Is this a situation where the contractor is submitting a bill to the insurance carrier for X, but actually did the work for significantly less money for the insured? Are there any addendums? Again, this is something that comes up with surprisingly a significant amount of frequency. Contract is signed. Anybody who's had work done to their house probably has come across this. Things change. Additional work is done. Things may be taken away from the scope of work. If we take these assignment literally, which most courts will, and it only relates to one contract, but yet there's 3 other addendums afterwards, you may have a legitimate basis upon which to question whether or not the contractor actually has a right to benefits under the policy for other work that was being done. Now let's complicate this, okay? Let's assume that as part of take a standard roofing claim with interior water damage. Contractor gets the assignment of benefits. The contract relates only to the roofing repairs and some minimal drywall work on the inside. Well, as the drywall is removed, additional damage is discovered. something that the carrier needs to go and adjust for. There's an addendum that is submitted afterwards, but is separate from this assignment of benefits. What that means potentially is that you as the insurance carrier may need to be adjusting the claim and working with not only the contractor, but also the insured relative to their own retained rights under the policy. Oftentimes, at least within the past, let's say 3 years, and where this really became an issue in Pennsylvania was the hailstorms that hit the Reading and Allentown area back in May of 2014. There were some outfits that came through the state seeking assignments of benefits. We're not going to name any names here today. But one of the things that the carriers quickly learned was that the estimates that they were receiving were inconsistent with the work that was being performed at the property. Now, again, this isn't going to be a fraud presentation, but in terms of how do we handle the assignment of benefits where you have the contractor coming in saying, here's my invoice. If you don't pay this, pay the benefits to me, I'm going to sue you. It's always a good practice to re-inspect the property and actually confirm that all of the work the contractor seeks payment for was actually performed. Treat this no different than if it was the homeowner making that same claim. You might be surprised when you go out and look at the property that maybe the windows weren't replaced where the contractor said they were going to, or the flashing wasn't repaired, or there was work that they said they were going to do to the chimney. It clearly wasn't done. These are very specific items that will allow you to go back to the contractor and the insured and challenge the claim payments, or at least question what's being done. Because the second point that we want you to take away from this is just because there's an assignment of benefits doesn't mean you automatically have to accept what the contractor is saying blindly. Here's the question that also comes up very frequently where you have these, and that is, well, does the policy's conditions and exclusions apply to the contractor? And what I will tell you is, if you look at the language here that we've highlighted in green, where the insured is transferring to the contractor all of the insured's rights, benefits, and proceeds due. When they use the word rights under the policy, I would suggest that that gives you a very reasonable and strong basis upon which to tell the contractor that they are bound by the very same provisions in the policy that an insured is. So you would be well within your right to ask that contractor for very specific documentation. Purchase orders showing exactly what materials they purchased at what cost. Documents showing how many people they had at that site working on this house over what period of time, to verify any transportation costs for materials that had to be shipped to the property. And if I'm reading the minds of the people out there, yes, you may be able to even ask for the contractor's examination under oath. Now, I will also tell you, honestly and candidly, in Pennsylvania, there are no cases addressing this issue as of yet. At least none that have been reported by the courts. But if we turn our attention to other states, and surprise, surprise, we're going to go with Florida. In Florida, the answer is maybe. And the reason why it's maybe is because it turns largely on the language of the policy and of the assignment of benefits. Other jurisdictions say yes. Pennsylvania, we don't know yet how they're going to turn out. But this is not something that I think carriers should give up without a fight, especially where there's some serious questions about the validity of claims. Now, before we leave this topic to talk about the impact on the insurer-insured relationship, which is probably going to be one of the most important components of this presentation today, I want to talk a little bit more about the claim process, okay? Just because an assignment of benefits is signed, that also does not mean that you should not continue to communicate with the insured. Reservation of rights letters, if you're investigating claims by the contractor, should absolutely be sent out. The insured should be kept in the loop as to all of these developments, because what you may find is that the insured could be your best friend throughout this process. And if there's anything that is suspicious or questionable about the work that's been done, your insured is going to be your ally and the one who's going to be able to give you that information quickly and easily. Don't be afraid as well to take full advantage of proofs of loss. If the contractor is going to be taking the position that they've obtained all the rights under the policy, then you would also be well within your right to submit a proof of loss to them to complete. And remember, a proof of loss is more than just what the number is. The proofs of loss also generally require the contractor, whoever's signing them, but let's just talk about a contractor in the property context right now, to provide bills, specifications, invoices. They're very specific in terms of what documentation should be attached in support of that proof of loss. And I think that's something that sometimes we overlook because we focus almost exclusively on the number that's in the proof of loss. I want to go back to the proof of loss, or to the, the assignment of benefits for a moment here. Okay, let's take one other step back. And I want to look at the second to the last paragraph, because again, this is another issue that pops up and usually is in the context of several not so polite letters from the contractor to the insurance carrier suggesting that, well, you should not be paying the mortgage company. Your checks need to go directly to me. That should be a big red flag. You, or at least under a standard homeowner's insurance policy, let's not forget that the mortgage company under Pennsylvania law has its own separate insurable interest in the property. They still have the right to be listed and included on any claim payments, subject, of course, to your own company guidelines. I know different carriers differ in terms of what the dollar amount of that is, but the contractor can't circumvent that language. Now, there's a question that's been posed, and I think it's a good time for this question. And the question is there an argument to be made that a contractor who uses an assignment of benefits agreement with the policyholder is acting as a public adjuster? If so, are you aware of any guidance or enforcement actions the regulator has made related to unlicensed activity? That's a great question. And what I will tell you is that it's a very fine line in terms of whether or not the contractor is acting as a public adjuster. If the contractor is merely conveying his estimate to the carrier and discussing the damages and seeking to collect the payment, he's not talking coverage issues. It's just a matter, and I'm going to come back to your simple roof, the simple roof example, although sometimes these may not be as simple of a claim as we like. Contractor says the whole roof needs to be replaced for reasons A, B, and C. There's damage on both slopes. The roof is, you can't do this repair. It's a method of repair issue without damaging all of the other shingles on the roof. It's going to be hard to say he's acting like the public adjuster. Where he may cross that line is where the contractor starts trying to talk coverage issues on behalf of an insured. And now he's getting into, here's what Pennsylvania says about the wear, tear, deterioration exclusion, or is trying to give you opinions about whether or not the weather exclusion contained in most policies is enforceable or is ambiguous. I think there's a clear example of where he gets into public adjuster world and is potentially subject to some type of investigation or ramification by a Department of Insurance. Now, the second part of this question, am I aware of any enforcement actions in Pennsylvania? The Department of Insurance certainly could look at this issue. They haven't. The public adjusters who I've spoken to about this issue generally have not been as forceful as I would have anticipated in pressing this issue, but that's not the same in other jurisdictions. And what I can tell you is within the past year alone, down in Texas, the Public Adjusters Association filed a lawsuit against a roofing company alleging the unauthorized practice of public adjusting. And the complaint was very specific in terms of that contractor was essentially taking on the exact same role of a public adjuster, doing a lot of the things that I just said, no, they should not be doing here. But we have yet to see that to this point in Pennsylvania.
And Scott, would you say that one of the differences also would be, or let me rephrase that. Here I'm asking a question as one of the presenters, but would you say that the difference might be also the contractor's not really looking for a percentage of the settlement as much as they are just the settlement, period?
You're right. That's, I mean, basically, you could, to state it another way, if you're talking property damage, real property damage only, the contractor's looking for the whole nut.
Right.
He's not looking for half a nut here. But let me also caution that, okay? Because if as part of this process, and again, we get very busy, and you take a hail event, a significant weather event where you're trying to assist as many policyholders as possible. If you have a contractor who's, as part of the claims submission, is including a claim for damage to personal property, that should be a red flag. Okay, anytime the contractor looks for something beyond the real property repair, I think they've crossed the line.
Yeah, I still think the question is, as you said, Scott, it's a very good one, and an argument can certainly be made, as you pointed out, that this functions in many ways like a public adjuster. I think I would just want to echo and agree with what you were saying about maintaining that contact. I think that's also something that we can sort of assume we maybe as a company starts treating it a little bit like a public adjuster or an attorney, and we forget to stay in contact with our insured. And it's important, I think, as you said, to use the insured not only as our ally, but hopefully because they've had our company, there's some level of trust, maybe not with the company directly, but with the agency. And so I think that's another piece I want to highlight and echo of your presentation. I think is a great reminder that these assignments of benefits do not, in the same way as other public adjuster or attorney relationships, take the insured out of it. At least that's not been my experience, and it sounds like that might be true as we go along. In other words, you don't see these accompany with letters that say, do not contact your insured, do not send anything to your insured, that kind of thing.
I have not, but I also would not rule out that possibility. You know, the contractor is telling you that you need to deal directly with me, the contractor. Much the same way you see public adjusters, some of them still making that argument, even though the law in Pennsylvania has changed over the years. The contractor can't cut off the communications between you and your policyholders. The policyholder is the one who's paying the premiums. They're the ones who are, you know, looking to get the benefit of the insurance.
Yeah.
Did I answer that, Mike, there for you?
Yeah, no, that's good. Very
Okay.
good. Yeah.
All right. Now, let's jump ahead here. And for the last portion of this program, talk about what all of this means for your interactions with the insured. And I'm going to turn this over to Mike now to talk about, because in his experience, and he's been doing this a whole lot longer than I have, and he's been dealing with a greater number of insureds than I have, but he's also been very successful in helping to cultivate a very positive relationship with the insureds. And I think he'll be able to give everybody listening some good insights and takeaways on how you can better your relationship with the insureds and use that relationship to your benefit when dealing with matters related to assignments of benefits.
Yeah, thanks, Scott. A couple of things that where I feel passionately about or strongly about in this area, and want to highlight is, as I mentioned before, I think agency relationships are very important. On the mutual side, and I spent 20 years of my career on the stock side, certainly a little bit of a different approach and feel. Both companies, the one I'm currently with, Goodville Mutual, as well as my prior employer, we're all trying to help the insurer to settle. But when in a mutual setting, I guess I'm still maybe old-fashioned enough to just understand what this relationship's supposed to be, and that is that this company and our mutual companies are owned by the policyholders in the sense that they're all equal stakeholders. And so anything that, to me, takes away or increases the cost, and I think even though the examples of the increased costs were from Florida, I think they're applicable, they're relevant, and anything that drives up the cost of our insurance is something that all of our insureds pay, even if it's just a little bit more, because of the increased cost on a claim that didn't need to be that way. A couple things I think are important is obviously establishing a trust relationship with your agents. I know most of, if not all of our companies, and certainly our member companies, we sell our product, this benefit, through independent agents. And I think it's helpful. People still do look to their independent agents and want some advice for that. And I think it's always helpful for an agent to be able to understand the thought process behind this. Now, I don't know, just like there are public adjusters that show up while the house is still burning. There are perhaps attorneys that might show up in the emergency room. I don't know that we can ever prevent that from happening. Same thing if there's a contractor that's showing up the day after your house is burned down, offering you an assignment of benefits form. But I think some of this happens at some process early on in the claim. And I think it's important, first of all, to whoever your adjuster, if you're a company that has field claim adjusters, or if you use independent adjusters, to get an adjuster out there as soon as possible on any loss, really, and to start, and just to start establishing that relationship with the insured. And I think that comes down to having the right attitude, that you're there to try to help out, to pay what you can, to give the benefit of the doubt to the insured, to reassure them that you're not on opposite sides. And I find that that's one of the biggest positives that can happen from my side of things, because at times we'll even have agents, certainly in the public adjuster, for instance, that's even something in the areas that we write in are mostly rural in the 8 states we're in. And some states like Pennsylvania have more an issue than that than other states. But we find that most of our agents can really talk to an insured through and say, hey, there might be those rare instances where you're going to need a public adjuster. That's possible. Or certainly there are cases with injuries and so forth that you're going to need an attorney. But that most agents will understand and be able to talk to their insureds that there is nothing you're going to gain by having this assignment of benefits in place. And so, yeah, it boils down to trust, to that. I think it's also education of not only the agents, but also insureds. And Scott, as you can see here, is putting up this little illustration, and it's really true. And if you think about it, on a larger scale, the trust battle is one that we work hard at every day, all of our companies, building that trust. From the claims side of things, of course, it's happening, the relationship maybe is only happening for the first time on the claim side. And you're hoping that the rest of the trust that's been built up through the agent, through the company, through underwriting, accounting, the whole deal is going to transfer over to the claims. And in some cases, you're fighting a battle right away. That's kind of tough. There may be somebody who says, hey, I just don't trust you, period. But I find that conversations I've had with insureds as well as agents, I put it back on them and I say, so why are you trusting this person who's come into your neighborhood? Do you know this contractor? Well, a lot of times with these cases, they don't, or not intimately. They're not from the neighborhood, so to speak. They're not from the region. They're not familiar ones. And frankly, the ones that most of us know in our own backyards are not the ones that are involved in assignment of benefits. And to try to at least help the insured to say, well, what makes you want to trust them more so than your company? What has been your experience? And obviously, if an insured has had a good experience with you on a prior claim, perhaps, maybe it's even a minor one, then you're already really ahead of the game, because they, as this slide says, and I agree with it, Scott and I talked about this, and I do think that most of our homeowners, when it comes to a property claim, they want to trust you. I mean, they've invested in your company in terms of premium, for whatever the reason is. And when you come in to look at a property loss, I mean, they're asking you to insure perhaps the most expensive thing that they own. And many times, especially most claims for most insureds are not large catastrophic fire, water losses, the tornado blows away the entire house. Those are much smaller percentage, but on a smaller claim, a roof claim, siding blown off, whatever it might be, maybe a garden variety water loss, they're still actually saying, hey, I want to see this claim handled well, paid what I'm owed, because, God forbid, something much larger could happen. And if you don't come through on a smaller one, I'm wondering how you're going to handle the larger one. So, I wish as part of this presentation, I'd have a list of 5 or 10 things that you as companies can do directly to stem this. I think working at supporting whether it's legislation or even if it's just getting behind things like this, educational pieces, helps all of us to sort of fight this, because at the end of the day, you're insured still left with someone, and especially a contractor, maybe even more so than a public adjuster, somebody who does building, they know construction, they look around your house and they're very sincere. I mean, they go in to try to build a relationship as well. And yeah, sometimes maybe they're just promising a homeowner that they're going to get everything taken care of by them, and you don't worry about the financial details, which usually translates to, we'll see what we can make on our end and still fix up your home. And there's a separation between what they say they're going to do, as Scott pointed out, even with the reinspection piece, going back to that, there's a separation of the two. And as long as the insured doesn't exactly know what's being paid, maybe, and the contractor, might be doing some repairs that are less than what they said they would do, but doing the minimum and charging you for the maximum as the insurance company. To me, yeah, it comes down to education, to trust, to relationships. And so that, for our company and for what we try to do, is to try whenever we can, as many times as we can, to let homeowners know that we're here to take care of them. And I feel that if we deliver good claim service, and I know our companies, those representatives on the line here today, would probably say the same thing. If we do what we promise to do, I think that's one of the biggest things that can that can help in this area of assignment of benefits.
Mike, do you mind if I just jump in on that real quick?
Sure.
Because the one thing that I want to add to that is I think it's important for us to recognize that with this concept of trust, it comes in all different kinds of forms. What the insurance industry is selling, for lack of a better word, in terms of the trust, is the idea that we will be there for the policyholders when a covered loss happens. Now, that's different than the contractor who comes in, who's saying, I want you to trust me that I'm going to do a good job on this physical thing. And if you think back to the last time you had a contractor for anything, what's one of the first things that they do? They either pull out the list of references and say, here, call any one of these people and they will tell you what a great job I did. Or they will tell you, hey, I just worked on Miss Smith's home right down the street. Drive by it. You could see exactly the quality of our work. Now, it's harder for the insurance industry to say, yeah, drive by Miss Smith's home and she will tell you exactly what a phenomenal job we did handling her insurance claim. We can't do that for a number of reasons, none of which we need to go in here today. But in terms of dealing with the policyholder, there are some core principles that I think we can, focus on. And Mike touched on these. And let me see if I could just kind of spell these out for everybody here.
And Scott,
Okay.
as you're going down there, let me just say, we got another question, which I don't know that there's an answer to this. You pointed out some statistics from Florida, which I've noted are from a data call that they did. There was a question asked to us, is there any estimate of any numbers we could share that estimate the number of assignment of benefit claims in the state of PA and basically how much they're adding to the overall claim settlement values, very similar to Florida. I'm not aware of that data, and I don't know if you are, Scott, or not.
I'm not aware of that data, although I've been hoping that someone would come and put together that type of information. It certainly hasn't been compiled or requested by the departments of insurance or any of the trade organizations that I'm aware of just yet. Then there's another question that just came out as well. Does Pennsylvania need to work on legislation dealing with assignment of benefits to better protect consumers while still allowing the process if the consumer chooses to use this process? And what I will openly say is there is no legislation that I'm aware of just yet, probably because this hasn't hit Pennsylvania the same way it has in Florida or in Texas or even in Louisiana. And I know those three states are sort of the hotbed for this, with Florida being far and above the highest, having the highest number of assignment of benefit issues. But that's not to say it's not coming our way. I mean, you can kind of think of it as the tsunami that you hear about in the news out in the ocean. Maybe it fizzles out before it hits land. Maybe it hits with full force. We don't know just yet. And I think I know that's the reason why we wanted to have this seminar for everybody, to help give some guidance and suggestions so that we can continue to stay ahead of this issue and be able to deal with it in the best possible way should it come up.
Yeah, that's a good point, Scott. And that's what my answer would be to this. I think it's a good question. We'd all like to have some more data. And are we at the point where legislation is needed yet? No. I would say maybe not, but a good point. That's why we're having this, because we do see that it could be coming. And, eventually these things come to fruition, like the public adjuster, and it gets bad enough, and then there's some action taken, and rights are restricted, and maybe caps put on certain percentages. So when it gets bad enough, so is it bad enough in Pennsylvania? Perhaps not yet, but I agree with you. I think it's something we all just want to keep our eye on as it approaches. Yeah.
All right. Getting back to just kind of circling this around to start to bring this presentation towards a conclusion here, and then open it up for any questions that anybody else might have. As insurance representatives, we need to focus on the things that we do best: consistency, honesty, promise keeping, reassurance. I know these seem like somewhat esoteric concepts, but in practice, they're actually pretty straightforward. You know, consistency and promise keeping, I'll lump those two together for a moment. If you say you're going to show up at a certain time, you have to really try hard to show up at a certain time, because, you know, let's equate it to the contractor. One of the things that we all probably despise when we have someone coming to work on our house is when they say, yep, I'll be there to start at 9 o'clock. And you don't hear anything until 11 o'clock. And then someone finally shows up. And now you had to rearrange your entire day based on that. Honesty. Be open and honest with insureds. One of the things that I like about dealing with the mutual insurance companies is that they pride themselves on the relationship with the insured. If there's a question about coverage and whether a loss is going to be covered, you don't hide it. You talk it through with the insured, and you explain to them exactly what is going on in the claim. Believe it or not, they do appreciate that.
Yeah, that's a great point. Excellent point. I think, yeah, just keeping our commitments, promise keeping. Yeah, this sounds maybe like a hokey way to end this presentation, but I think all four of those are all the ways you can continue to, yeah, to be consistent, to keep your word. You know, do what you say. We all know we're in this business when not everything's cut and dried, not everything's clear. There are times when we have to do further investigation. There are times when we have to say, no, this isn't a covered loss under the policy. And we all understand that. And I don't think we're talking about, that's not where we run into the issues here. It's the keeping of our promises. It's letting insureds know that, hey, even if we need more time on this claim, we're doing it for a good reason. We want to get all the facts here. Or, yeah, we're going to take a second look at it. Yeah, maybe on this one, we're going to send an engineer out, or whatever we need to do, going the extra mile to say, really, we want to pay what we owe here. We're not trying to work and seeing how we can get out of a claim, but we're working to see how we can pay what we can pay for the amount that's right. And Scott, I have to actually have a 3 o'clock conference call that I need to be on, so I'll be having to cut this off shortly here. So it's been enjoyable here and very educational for me too, even as a panelist on this subject.
Well, Mike, thank you very much. Everybody, I know it's we're coming up on to 3 o'clock in the end of this presentation. If anybody has any other questions, feel free to pose them now. Otherwise, feel free to reach out to us after this presentation. All of our information is with Vaughn. I'm part of PAMIC as well, and we'll certainly answer and help in whatever way we can.
Sounds good. Yes, thanks for your attendance today. Appreciate your good questions.
Yep. On behalf of PAMIC, I just want to thank everybody for attending today's webinar. We hope that you found the presentation to be valuable. I know that I got some value out of this presentation. Scott and Michael, great presenters, and we really appreciate them taking their time to be part of this. The video from today's webinar, as well as the slides, will be available on our website, as will Michael and Scott's information on how to contact them. We're going to be continuing our webinar education in April with an interview with someone from the Pennsylvania Insurance Department, Christopher Monahan, and Joel Hopkins will be the interviewer from Saul Ewing. So that should be an exciting webinar where we talk about some of the market regulation coming up. Again, I want to thank our Premium Gold sponsors for making this event possible. We really value their support. of our organization. So thank you guys for attending, and we'll see you on April 26th.